Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our Thursday community conference call, which we hold every Thursday, once on our private bridge, which is where you are today, and once on LinkedIn audio. Today is September 21st, 2023, and you're all welcome. I am going to go through the questions that have been posted on the forums first. I will invite you to ask any follow-up questions while I'm discussing those items. No new questions, only follow-ups to what I've discussed. At 30 minutes into the call, I will lock the conference so no more people can log in. And then I'll proceed to answer all the new questions of everybody who is in the conference at that time. So I intend to cover everyone who remains after 30 minutes in the call. Okay. If too many people log in and I feel I can't really handle everybody, then I'll close the conference early, but I will still make my very best efforts to answer everyone's questions. Who's here? When you logged in, you heard our standard disclaimers. They apply to everyone. With that, let me get started. Today, it was unusual. I did not mark any questions as frequently asked questions. Normally I do, and I discuss them first. So in the order these questions have been posted. The first one is from Sadia K. This question talks about options for a career break on H1B. The I-140 is approved. What happens with the H4, travel, part-time work, etc.? Currently, I'm working on an H1B. I-140 is approved in July 23. Spouse is also working on H1B. I want to take a break 1 to 2 years from work to take care of my child. After I complete 180 days from I-140 approval. Good. What would be my options? Number one, thinking of switching to H4 for a couple of... Sure, that's a great route. Why not? Your green card application will not get affected as long as, well, first of all, when you have converted after 180 days to H4 and your I-140 remained approved, you have preserved all your rights under the green card. What are those rights? Keeping your priority date, which is a right you secured the moment your I-140 is approved. On top of that, you also secured the right to keep extending your H1B past 6 years with any employer, not just the sponsoring employer. And this is true even if the sponsoring employer revoked your I-140. After 180 days, you become secure. Okay. So now, would the employer continue to process your green card and wait for you to join back? That's an entirely different set of questions. And can you do that? Ability to pay wages issues. Those are things you should be talking to your lawyers about. Would the employer have the ability to pay me even if I leave them? That's a very technical question. They have to look at the tax returns, etc. And two, what was the second point I was trying to make? So I've left. Oh yeah, the intention to join back and the intention for the job to continue. Those are all technical issues connected intricately to fact patterns. But theoretically, this is a great way to go. H4 is no issue. You can always convert back to H1B. If my current H1B is from October 21 to 24. If I switch to H4 in Jan, will my H1B timeline hold? Yeah. The moment your H4 change of status is granted, your H1 clock would stop ticking. And that's not really a problem for you anyway because you have an I-140 approval. And that gives you a very long potential for repeated H1B renewals until your green card dates become current. As I mentioned earlier, okay, one second. And if I start working after 2-3 years, will my H1B restart from remaining 10 months of my 3-year H1B? Exactly. So the time that you actually used will be subtracted from your 6 years. And when you join back, you will have that remainder left. You will not have the entire 6 years. As I mentioned earlier, my husband and I both are on initial H1B, never went to India for stamping. We have our old F1 visa in our passport. How easy is it to travel? There is no number I can give you how easy it is. depends upon your husband's H-1B. That's a discussion to be had with his lawyers, because his case is the one that you primarily need to worry about. Yours should be straightforward. And yes, you have to get a visa stamp. And again, visa stamp does not impact either your ability to convert back to H-1B or your green card. Can I work part-time, less than 30 hours instead of full-time on the same H-1B? No, you have to amend it. You can, and there's no limit to how low you can go. Okay, there really isn't. So you could definitely work on the same H-1B, but it has to be amended. An amendment has to be filed. Okay. Press *5 if you have a follow-up question on anything I've discussed. No new questions. Follow up on what I just discussed. Okay. I have 2 questions. Please make sure, folks, that these are follow-ups and not new questions. Okay. So let's start with, in the order that you called in, area code 413. Let me find you. 413 is Massachusetts. Massachusetts, I can hear you. Go ahead, please.
I'm sorry, but I don't have a follow-up question.
Okay. Then you need to, just press *5 again and put your hand down. Okay. Thank you. Then I have one from area code 336, which is North Carolina. Okay. Yeah, North Carolina, go ahead. North Carolina? Did you forget you are from North Carolina? Area code 336?
Hello,
Yes.
Rajiv, can you hear me?
Yes, ma'am, I can.
So I have follow-up on that question. So if I work part-time, you said I have to amend it. Does it have to be on-site, or can I work remotely if I do the amendment?
No. You can work from one site remotely or multiple sites remotely and from the office and from a third location. All of that can be accommodated in the amendment.
Okay. It's just that my employer has to agree for that amendment.
Well, amendment is a lot cheaper than extension or refiling or transfer. Just make sure they figure out the charges. It's going to be a lot cheaper for them. Okay?
Okay. All right. Thank you, Rajiv.
You're welcome, ma'am. Good luck and congratulations.
Thank you.
Bye. Okay. Going back to the next question. Hang on, did I cover this? Yes. Considering further education and employment alternatives for F1 CPT visa holders post H-1B lottery denial. So I am doing my curricular practical training, never worked on OPT. I started my second master's right after completing my first and started working for a fintech company on day 1 CPT. Company filed H-1B, not selected, both lotteries. My master's program will end next year in June. Visa is valid till 25. Would you please let me know if it is legally possible? Yeah, it is possible to enroll in a third master's or a PhD. The only thing I always tell people who are going for curricular practical training, I always think of immigration law as requiring, even if it is not written anywhere, requiring good faith. So in other words, we should not be trying to exploit the system. So make sure that if you select a master's degree for your CPT, in good faith, you can account for the fact that it's enhancing your career. So for example, if you have a degree in rocket science, or something equally exquisite like that, and then you want to jump into a degree in liberal arts, that's probably not going to look very good. Okay. So anything that enhances your career and your career goals should be okay. All right. So it is legally possible. Yes, that's all you had. *5. If you have a follow-up question on this, press *5. Going on to the next question. Employment changes an I-140 filing for green card process with an approved PERM. employment changes during the green card process impact on perm. Employer filed the perm, not approved. They are going to support through the entire green card process. They have no intention of withdrawing the I-140 once it gets approved. Is it legal to file I-140 without being continuously employed by the sponsoring employer? Sure, absolutely, it is. But discuss with your lawyers the details. It can be done. Or is it legally permissible to change employers before I-140 is filed? Even that. See, the whole idea is that I have a job with this employer. For whatever reason, I'm leaving, but I intend to come back either before or after the green card approval. And the employer has the same intention. Your lawyer should explore these issues with you. But if there's a continuing intent, I don't see any problem. This is done all the time. Yeah, they can file an I-140 even though you're not working. It's done all the time. Do check with your lawyers to make sure some of these finer nuances are discussed and covered. Okay. *5, if you have a follow-up question on this, press *5. Okay, this is from area code 858. Don't know where that is from. 2 follow-up questions, one from California, one from Texas. I've got to go to Texas first because they logged in first. Okay, Texas, go ahead, I can hear you. Area code 469.
Hi, sir. Yeah, so, but while applying the form or while we filing the electronically, right? So we mentioned that we are working as a current employer, right?
Okay, stop. Stop. The information that you provide to the government should only be correct on the date it is filed. If the next day the information changes, there is no problem.
Oh, okay.
Okay. Anything else?
Okay, cool. That's it.
Good luck. I know what you are going to ask me. All right. So next question is from area code 858, California. Go ahead, please. California, bear in mind, I'm not taking new questions, just a follow-up on what I discussed. Okay, you're not talking, so I'm skipping you. Going back to, okay, we discussed this. Next question, Saeed. Saeed says, USCIS email regarding visa petition processing and NVC contact requirements. So I just read this question a minute ago. Do we have to keep contacting NVC every year? No. What they are basically saying is, we'll send you a bunch of forms if you are the petitioner or party concerned, and you have to get back with us with all the information within 1 year. After that, you don't have to keep calling them. Once you've submitted the information, you are done. Press *5 if you have a follow-up question. Press *5. Yeah, it's a good question because, it sounds like you're supposed to contact them every year. The answer is no. When they send you the forms, etc., for follow-up, fill-ups, etc., like affidavit of support, you must submit everything within 1 year. Okay, after that, you don't have to keep calling them. So, all right, let's go to the next. Oh, is there a follow-up on this? Sorry. *5. If there's a follow-up, then this, press *5. Okay, very good. Then this is done. Now come DS-160. I can't help you fill forms, guys. I have a problem with that. In DS-160, should I put my work location, I'm working from home, etc.? And the answer is, the question is actually quite simple. And I can't help you answer the question, but I can tell you this. The only information that is relevant is where you are actually working from. Whenever somebody asks you what is your work location, it will be where you are actually working from. If you are working from 2 locations, then you might have to give both locations. But if you are working only from your home, then obviously that's the only work location that matters. Where your employer is, where your client is, irrelevant. Okay. Press *5 if you have a follow-up question on this. Press *5 on your phone. Okay. Coping with I-94 confusion following recent travel to Canada seeking resolution. So you travel to Canada visa was expiring in October 23. You have the same I-94 number as same, okay. Because of this, the current I-94 online shows valid till October 13th, 2023. Okay. You asked to update officers that come back a couple of days before I-94 expiration. Yeah, you do need to get this renewed, because the way it works is when you exit USA and come back, that's your most recent I-94 if they issued you a new I-94. Whichever is your most recent I-94, if it came with the H-1B approval, that is the most recent one. You've got to get this corrected. Definitely. Now, if you don't have you still have a visa stamp on your passport, right? It is good till October 2023. So if you leave USA and come back again, you can insist that they issue you a new I-94 if you show them the visa. You can use the old H-1B visa and a new H-1B approval. And the I-94 they issue you should be coextensive, not with your visa, which is expiring in October, but with your approval, which is expiring in 2026. So I-94 they issue you should be good till 26, and you need it. Okay. Any follow-up question on this? Press *5 if you have a follow-up question. Okay. Next question is from I-485 employment-based adjustment, interview pending, balancing relocation plans and interview attendance. So you have a 485 pending, ready for interview. My house closing is within a week and I'm planning to move to another state in a week's time. Can I attend the interview? Should I postpone my move? Okay. So what happens is, in these cases, there are two possibilities to the best of my knowledge. Let's say your 485 is pending in location X and you move to location Y. X can choose to complete your case, take your interview, and finish it up. Or X can choose to transfer your case to location Y where you have moved. That could cost another few weeks. I don't know how much delay. I can't really predict. So the simplest thing is not to move. But if you have to move, then so be it. Okay. *5 if you have a follow-up question on this, press *5. All right. Visa solutions for relocating to USA for business, seeking alternatives to ESTA. Okay. So the CEO of a company has asked me if I should come to the USA and work directly with him. I live in the UK. Can I come on ESTA and work my... No. ESTA does not allow you to do business. It also does not allow you to work in the United States. If you do, it would be illegal. What would be the visa option? Look into E2 visas, which is if you want to invest a couple $100,000, maybe a little bit less, you can look into that and come to manage that investment. People have done all sorts of different kinds of businesses, including e-commerce, things like that. So I think that could be an option to consider. In my mind, E1, E2 can both be options. E1 is for those people who have already ongoing business relationships and trade, whether it is in goods or services, with USA. So E1, E2, E as an elephant, treaty trader and treaty investor. Look into those visas. Okay. ESTA is not a method of coming to US and working. Press *5 if you have a follow-up question. Please press *5 on your phone. All right, let's go on to the next posted question. Immigration considerations after expungement of retail theft charges. You had written to me, I had responded to you. So this question is probably quite old, and we have already talked on the email. I told you what to do. I'm not going to address this. Next question is Parmodit. Okay, I'm looking at it thinking it's Parmadit. Parmadit 87. Okay. Name change evidence for Form N400 options when legal documents are unavailable. I'm filling up N400 for my mom. I have a question regarding name change evidence that they are requesting. If you have changed name any times, bring the document that legally changed your name, such as a marriage certificate, divorce certificate, name change. Her name, my mom's name, is different from the name on the birth certificate as a result of her marriage to my dad, but she has no such legal document. But you know, she has proof of marriage, right? So you can get your dad's passport, provide a copy of it saying that she changed to her married name, and maybe even get a couple of affidavits of people who attended the marriage or know when the marriage occurred and the fact that she's married to your dad. All of that could work. Copy of his passport showing his last name that she has then taken, as well as a couple of affidavits from people who attended the marriage. That should do it. *5 if you have a follow-up question. No new questions. *5 if you have a follow-up question on what I just discussed. Okay. Next question. We have only a couple of questions more, and then we'll start taking new questions. Green card holders stay in India after EB1C. So this question was, if I get my green card, can I just stay in India and come to US? And no. That's not how it works. If you get a green card, you must have your permanent home in the United States. Actually, if you Google my name, Rajiv S. Khanna, space Economic Times, you'll come to my page, and in my comments on the Economic Times, you would see a comment about how to maintain your green card after you get it. Okay. You can, however, look into getting a re-entry permit, which allows you to stay away from the US for up to 2 years. It can be renewed again, come back and renew it for another 2 years. So typically, a re-entry permit can be an option. But just coming to USA a few days every 6 months, that's not good enough. Your permanent home should be in the United States. Okay. *5 if you have a follow-up question. Press *5 if you have a follow-up question. Okay, you do not. Let's go on to the next question. Using pay stubs with short-term disability for H1 transfer during FMLA. Yeah, so when you are on family medical leave and you are obeying all the rules of the FMLA in your state as well as the federal rules, you do not need full pay stubs. And the short-term disability, etc., those pay stubs should be used for H1 transfer. I don't see any problem with that. Press *5 if you have a follow-up question on this. No new questions, follow-ups only. Okay, last posted question. USCIS payment authorization issue. Okay, I have no idea about this. Nikhilji, I would suggest that you talk to the USCIS customer service, ask them what they want you to do. We have never been in this situation. I would actually have to make a few phone calls myself. So I have no idea what you should be doing when your payment is in doubt. Okay. So talk to the USCIS customer service. And of course, you can always refile your paperwork, your green card, the I-130, all over again without waiting for a rejection. Attach a letter that explains why you are doing this, and that should be okay. Okay. Press *5 if you have follow-up question on this. Press *5. All right. So I'm going to lock the conference. I'm just going to attend to the people who are already here and make sure I answer all your questions. Give me 1 second.
The conference is now locked.
All right, folks. Anyone who has any question, press *5 on your phone. Anyone who has any question, press *5. Okay. I have 5 questions so far. All right, that's easy enough. Let's proceed in the order that you logged in. Give me 1 second. This darn computer. You know, when you go from Mac to Windows, Windows to Mac, it can get silly. Okay, so there is somebody from India who has called. Let me see if I can find you on my dashboard. There you are. India, go ahead. I can hear you. India.
Hello?
Yes, sir.
Hello, am I audible?
Yes, you are.
Okay. Hi, Rajiv sir. Thanks, sir. So my question is, I had my H1B stamped in November 2015, 2015, and I went to New York and I worked for a couple of months, and then I came back to India. So now I'm working in Canada with a company, and that company is also in USA. So my question is, can I work for remaining 5 years, 9 months?
Oh, absolutely.
Yes or no? And
yeah, absolutely.
Okay.
Let me have hold on. Give me time to finish my thought. So what happens is, in a case like yours, you have the option to remain outside the lottery, no lottery issues, as long as you're willing to take the remainder of your H1B, which is 5 years, 9 months. Okay. So that means your H1B can be transferred to any US employer, the same employer also, and you can come and work in the United States. If you want to Google this, it's called the remainder option H1B. Okay? Go ahead.
Okay. And what is the application type that my company needs to file, or is it just a transfer?
Yeah, don't worry so much about the nomenclature. You can think of it as a transfer. That's good enough.
Okay.
All right. Anything else?
Okay, yeah, so yeah, I'll take care of rest of the things. Thanks.
All right.
No, I'll take care of rest of the things. Thanks.
Good luck. Texas, area code 469. Go ahead, please.
Hello, Rajiv sir. Good afternoon.
Good afternoon, ma'am.
I had called in earlier also regarding my H1B situation. So I had mentioned that I am on F1. H1B got picked. Then I got laid off. Then H1B got approved. Now withdrawal is also pending with USCIS.
Okay. All right.
So my question is, starting October 1st, I am actually attending a couple interviews now, which might turn into offer in the next week or so. So starting October 1st, should I report my status to them as somebody who has an H1B and should get a transfer of it, or should I still call myself as somebody on F1 STEM EAD?
Okay. So right now, what the school would have done is, the school would have put you on gap EAD, and they would have suspended your service. Okay. Now, you said your H1B is going to get revoked. Is that what you said?
I don't know about whether it will get revoked or no, if that's the terminology, but the company has filed for withdrawal and the law firm has applied the same with USCIS already.
So I think it is best for us to assume that your H1B would be revoked before October 1st. Because government, when they receive the withdrawal or revocation request, they actually connect it to the date of the filing usually. So if the request was filed before October 1st and USCIS acted on it after October 1st, they will deny it from before October 1st. So it looks pretty obvious to me that you're going to lose the H1B and be back in the lottery merry-go-round. Okay. Now the problem is, you need to reinstate your STEM OPT. Okay. How do you do that? The only way you can reinstate your STEM OPT is when the government, USCIS, acts on your case to revoke the H1B. Unfortunately, there's no prediction how long they can take to revoke. To make things even more complicated, if after October 1st, your service is still suspended, your H1B is on its way to be revoked and still not acted upon, Are you losing your unemployment days? Nobody really knows the answer to that question. So what you should do, and I've told this to every student in your situation, first call SEVIP. You know what SEVIP is? SEVP. They are the people who maintain your SEVs.
Yes.
Actually, let's make it even simpler. First call your DSO. Explain the situation to them, and they should tell you what I have told you. They can't do anything without the H-1B officially getting revoked. You can tell them I can provide proof that the lawyers have sent the request. Usually the DSO cannot do anything with that. Okay. Number one. Number two, you call SEVIP and tell them the same thing, and they will also answer the same. Why I'm making you go through all this? If in case there's a problem and you end up in court, you should be able to show the judge that you tried everything under the sun to protect your status. Okay. Third thing you do is call the USCIS customer service and try to open a service ticket to tell them that, look, I don't want to be a part of this H-1B. I want to get out of it, and I want to go back to my OPT. What can you do for me? Ask them. The last thing you do is you open a request with the USCIS Ombudsman's office. You know what that is, ma'am?
Yeah.
Open a request with them, mark it urgent, tell them what the situation is, and tell them this is the problem in the system. Because I am running on my STEM OPT time after October 1st, we don't know what the situation is, and the government is taking too long to act on these. Please help us. This is affecting many, many students, not just me. These are the only 4 things you can do, ma'am. Okay?
Yes, sir. You had suggested this, and I actually did all these 4 that you have mentioned, have proofs of me writing emails to them. I also did contact the senator's office like you had suggested last time. But all of it ultimately comes down to the fact that USCIS has to take a look at my case, which has still not happened. So I don't know.
No, there's nothing else I can suggest to you. Ma'am, there's no point talking about it because there's nothing else I can suggest to you. Other than filing a lawsuit against the government, there's nothing else you can do. Not a thing. Okay.
So do you recommend, sir, that I go ahead with F1 as my status? And I don't know, because if the employer submits for I-9 or
well, you don't have work
authorization after October 1st.
You don't have work authorization right now, so you can't really tell them anything. You can tell them I'm in between status. I'm waiting to be converted back to F1 OPT.
So would that mean I cannot accept the job offer?
You can accept it. You can't work.
Until my F1 services is again it's come back to normal?
Yes, unless it is reinstated, you can't work. All right?
Okay. Thank you, sir.
You're welcome, ma'am. Good luck. I have now all of a sudden 7 people with questions. What is going on, guys? Were you taking a nap? All right. So let's go with, again, the order is changed. In the order that you logged in, we are going to go to area code 413 first, which is Massachusetts. Massachusetts, go ahead.
Hello. So I'm on, my H-1B was approved last year and it's valid till 2025. I'm unemployed right now and my 60 days end on October 10th. I plan on doing a change of status to B2 because I have a valid B2 until 2026 to give myself more time in the country to continue
stop, just stop ma'am, stop for a moment. The B2 visa stamp that you have on your passport means nothing. It does not help you inside the United States. So don't think that is somehow sufficient. You have to apply for a B2 like everybody else using form I-539. Go on.
Once that process is completed and it goes through, if I were to get a job, would I have to re-enter the H-1B lottery or can it be picked up again?
Okay, so you used to have an H-1B. You got into the 60-day grace period after the termination. The question is, if I convert to B2, do I lose my lottery? No. Of course not. you can go to an H-1B without having to go through the lottery again. No problem. Okay?
Okay, thank you so much.
You're welcome. California, area code 323. Go ahead, please.
My situation is a little bit the same as the previous person. I was on a H-1B, but it was all cap exempt.
Oh.
However, I transferred from employer A in May, and then end of May-ish, and then started with employer B in the middle of June. And then at the end of July, I got an RFE for employer B. And then now in September 8th, the employer B terminated the employment. And then we were still working on the RFE, on the pending application. But then now they withdrew the pending application, or we're in the process. The company lawyer told me this week that on Tuesday, actually, they sent the notice.
I can't hear you, sir.
I'm currently...
I can't hear you.
I can't hear you, sir. I can't hear you.
Hello?
You hear me now?
Yes.
Hello?
Yeah.
I can hear you. Can you...
I can hear you.
So, I don't know where I left off, but...
yeah, the company lawyer, something withdrawn, something... I don't know what you're saying.
Yes. So, the company lawyer said that they sent the withdrawal notice on Tuesday, this Tuesday. And then I've been working with my lawyer on my end on the B1, B2 visa case. But
sir, your voice is breaking up. Hello? You are fading in and out. I don't know what is going on at your end, but this is getting very difficult for me to understand. So you are working with your B1, B2 lawyer. Speak up a little bit, please.
Okay, so I was working with my B1, B2 lawyer, and then right now, just the pending application is making the difficulty in the situation where right now I don't have a status because my employment was terminated while the application was pending. So that's the issue here.
Well, you have the 60-day grace period, right?
So I guess I have to, the thing is, my 60-day grace period for my first visa, it already ended.
Okay.
Employer B, it was a pending application.
So yeah, this is more complicated, and your lawyer should have discussed it with you. This is more complicated than just a routine B1, B2 transfer, because the moment your pending H-1B is withdrawn, you no longer have status. In fact, you no longer have status even now, because the old H-1B plus 60 days have expired. Yeah. So you are in a suspense status, which is called authorized period of stay. As long as the application is pending, you are in authorized period of stay. But you cannot convert to B1, B2 from authorized period of stay. It is not allowed. So, of course, the government has the discretion to allow it, but they hardly ever do. So your best bet is to leave and come back on another H-1B. Okay?
Okay. So I shouldn't even try to file?
No, I think it's a waste of money. You should talk to your lawyers. I don't know what they are thinking, but in my mind, this is not approvable. You cannot go from being in between applications to B1, B2. They won't allow you.
Okay.
All right?
All right.
Good luck.
Okay.
All right, sir.
Thank you.
All right, bye-bye. All right. Pennsylvania, area code 412. Go ahead, please. Pennsylvania.
Hello.
Yes, sir. Go ahead.
Sir, so I got my H-1B approved last year, but right now, I'll have to change. I'm looking to change of status since I left my job some time back. So if I change my status, right? So can I, let's say I change it to F1 visa or anything like a B2 visa? Can I stay in the US while the petition is pending?
Sir, remind me again. What is your current status?
Right now, I'm on grace period.
What was
an
the
H1B.
before? Oh, you are on H1B grace period, right?
Yeah.
The 60 days after your H1B termination occurs. Okay. So, well,
Yeah, right.
if you want to convert to B2, certainly. And if you want to see the details on how to do it, just go to our website, immigration.com, and on the top ribbon, there is my blog, Rajiv's blog. Go there, fourth or fifth entry tells you how to file a B2 in these circumstances. Okay?
So will I have to do the stamping as well, or is it fine?
No.
Just do it
You
in
can
status?
stay in the United States while the application is pending. All of this is covered in my blog. Okay? If you
No stamping is needed, right?
no stamping. Stamping is only needed if you travel outside the US.
Okay.
Got it? So if you
Okay,
file
that
the
makes
application within those 60 days, then you can stay for the next several months until the case is decided. Okay? And if you need to extend that, you
So
can file.
let's say if I
Go ahead.
sure. So let's say if I change the status to, let's say, F1 visa instead of B2. So even in that case, like, I don't have to travel outside the US to get the stamping.
That is
done.
correct. That is absolutely correct. Yes, sir.
And I can stay in the US. Okay.
Makes sense?
Okay. Thank you.
You are very welcome. Good luck.
Sure. Thank you.
Let's go to California, area code 858. California. Go ahead, please.
Hello, good morning, sir. Good afternoon. Can you hear me?
Yes, sir, I can hear you just fine.
Is my voice okay?
Yes.
Actually, I had a question on follow-up question on one of the previous questions, FAQs you took today on perm application.
Okay.
So, if I have multiple previous employer experience, which I want to mention in my application, so will I have to get experience certificate from each one of them?
Yes, any experience that you want to be included as a part of the requirements of the job, that you have to document it through letters from the old employer on their letterhead. And there's a particular format which your lawyers should be able to help you. So the idea is, let's say that I have 9 years experience, okay? And my perm application says you must have 5 years of experience. How much experience do you think I need to document? 9 years or 5 years? Make a guess.
5.
Exactly. So I only have to document the experience that I am seeking as a part of the requirements. Make sense?
Yes. So, and out of the total experience, if there is something which I don't see it is relevant to the job,
you can let it
job,
go.
then I don't need to mention.
Absolutely. You do not need to document that which is not relevant. All right.
Even if it shows a gap in the experience, then?
Sure. No. In the perm form, we list all that experience. It is not like we don't list it. We just don't document it. So if the perm form provides enough space, I would list all the 9 jobs, but I will document only the ones that I can. It could be my first job, my third job, my 7th job, and my 5th job. Doesn't have to be in order either.
Okay.
Makes sense?
Understood. Okay. Thank you.
You're welcome. Good luck to you. All right. So let's go to New York. I thought it was Rochester, Minnesota. Hi, New York. Go ahead, please. Area code 585.
Hello, Rajiv. Thanks for the call. A little bit tricky case. So I had my EB2 140 approved in 2012. Then in 2020, October, 485 was filed by Company A along with I-140 EB3 downgrade. Then
hang on. Okay, so this is a very weird situation. Let's say there are 2 employers involved. Employer X who did the I-140. They did the perm, they did the I-140. Then you joined employer Y. Do I have it right so far? You joined employer Y.
So far, No, I didn't join employer Y. Employer X only filed the 485 along with
Acha.
EB3 downgrade.
Oh, okay, that's simple enough. All right, so then what happened after that?
Yeah. After that, after 180 days, I moved to a new employer while the I-140 EB3 was not approved.
Oh, okay.
Now in 2023, the old employer got an RFE on the I-140, which was the downgrade EB3.
Got it.
And the old employer withdrew my I-140 application.
The
now,
EB3
the tricky part happens is
the EB3, hang on, EB3 downgrade, they withdrew that.
Correct.
Okay.
But my new employer had already filed I-485J, and in that 485J application, they had put the EB2, you have to put a receipt number, right? So they put the EB2, which was approved application.
Yeah, that case is going to get thrown.
Attorney,
hang on, that case is going to get thrown out no matter what you do. Okay?
Okay.
There is no way it can be approved. Why? Because even if they had put the right receipt number, the I-140, the EB3 I-140 was never approved. Okay. If they had put the EB2 receipt, then they are not entitled to do anything with that because the dates were not current, 485 is not attached to that. So I don't know what survives. Okay. This is a tricky situation. Somebody should look at your paperwork, advise you what the grounds for revocation were, and whether even the priority date survives or not. But definitely the green card does not survive. You should start all over again from scratch. Okay?
So then my follow-up question would be, so the USCIS cancelled the 485 application.
Sure.
They did not cancel the 485J so far.
That doesn't mean anything. Hang on. That doesn't mean anything. What you're saying is, I have a 3-story house. First story was knocked out. Can the other 2 stories remain? Of course not. The ground floor is gone. You're done. So don't waste time, spin wheels, thinking about ways out of this. Best thing to do, start another green card. Hope to preserve your priority date. You might even end up in litigation because there are some tricky issues here. But can your green card survive as it is? Absolutely not. Can your priority date survive? Depends upon the reasons for the revocation.
Okay, so then my last question would be then, if I entered US on advanced parole, and if my EAD, if my 485 has been denied, am I then out of status?
Yes, you are.
I'm still having H1 till next year.
Oh, do you have an H1B? Hang on. You have an H1B with an I-94?
Yes.
Okay. And you are working with the employer who sponsored you?
Yes.
And you have the same job, no changes, nothing that needs to be amended?
So far not, but next month I may be changing my job, yes.
Oh, that you can do an H1B transfer.
File my new H1.
So, this is what I would say. If you were actually working on the H1B, the fact that you traveled on advanced parole should not be a problem. Okay? But this is tricky. I don't think it should be a problem because you got an H1B with an I-94. To me, that should be sufficient. Okay? But here's what you can do if you want to be even more careful with this. When you do your H1B transfer, just go get a visa stamp from Mexico and come back. It's easy enough.
Okay.
Okay? You should be fine.
Yep.
Good luck, sir.
Thank you.
You're welcome. Bye.
Yeah, thanks.
Okay, so last question is from Indiana. Let's go to Indiana. Yeah, Indiana, go ahead, please.
Yeah, hello, sir. Quick background. I was on F1 status till my OPT end date in July of 2023. And now I'm on H1 cap, and it's effective in October. No change of status. Now, earlier, when my petition, H1B petition was filed by my company, they filed it as remote employee because I was working remotely from Wisconsin at that point in time. But now the company is working on an amendment because I moved to California and they will be filing the amendment this month. So for like my question is, I am traveling to I intend to travel to India early next year, and I want to get my stamping done. Would I have to wait for I-797 to be with the new petition number to be available to get the stamping done in India?
Ma'am, there are a couple of issues here. First of all, should you get a visa stamp on the old H-1B approval? I don't think so. Should you get an H-1B visa stamp on the new approval? Yes, I think so. But can you make an appointment with the old approval and then change the appointment to the new approval? I think you can. I know, again, I've never done this personally, but I know it is possible. How do you find out? You go to the frequently asked questions of the contracting agency that works with the State Department. Okay. You know, what are they called? Visa something, whatever they are called. Do you know who I'm talking about? The people who receive your paperwork for the Dropbox and all those things. If you don't know the name, I can give you.
Yeah, like the Postmax Center.
No, hold on one second. So, getting US visa in India. Let me tell you what their I forgot what that service is called. I always forget their name. So USA, for more information, click here. Travel Docs, the Travel Docs people. Okay. So you can go to the Travel Docs frequently asked questions on visas. They have covered this issue. You can also go to the State Department, travel.state.gov, frequently asked questions on DS-160. They have covered that issue there also. So I think you can double check it. But you have another option. You can always go to Mexico and get a visa stamp even before you travel to India. Mexico wait time is only 3 days.
But so but in both cases, I would need the new petition number available before the appointment.
You will actually need the approval before the appointment. So what I'm thinking is, what if you make an appointment with the old number, and then when the new number comes, you change it. Okay. So I think that can be done. But don't take my word for it. I haven't done it. I remember reading a fact on this a time back. So read up on it. How can we change the information on a DS-160 when it has been filed?
Okay, but it would not be ideal for me to get a stamping done with just amendment being filed on the old.
I don't think so. I don't think. Yeah, I don't think that's a good idea. Is it possible? Probably. Can the consulate make an issue of it? They can. So then you would have lost your turn at the visa stamping. Okay.
Okay. And another question.
Make it the last one because I got to go.
As of now. Okay. Yeah. So the other question is, right now, based on the questions that I've answered in the travel website for booking an appointment, it says I'm eligible for Dropbox, but from US consulate's website, and they say the interview waiver option is effective until December 2023 only. So for me to, kind of file something in early next year, how do I determine which category I belong to?
Currently, do you have an H-1B visa stamp? Did you ever take an H-1B visa stamp?
No, I was on F1. I came to the US for a master, so I have an F1 visa stamp.
So if by the time you go for the interview, they have scrapped the interview waiver, you are not entitled to Dropbox because you are not applying for F1, which was your previous visa. So therefore, if in December they don't extend the interview waiver, I think they are going to, frankly, but I don't know for sure. If they don't extend it, then you are stuck with having to go through the interview. Okay?
And I have to like book a new. I'm assuming it's
That I don't know.
a new appointment.
That appears to be quite
okay.
obvious because obviously previously you didn't have an appointment. So I don't know those details. I never get into those details. Somebody in our office takes care of all that. Okay. Good luck, ma'am.
Okay. Thank you so much.
You're welcome. Bye-bye. All right, folks, that's it. That's all the time I have today, and I'll see you again next week on LinkedIn. Great talking to all of you. Take care. Bye-bye.